Republican Vice President J.D. Vance wrote what might be the most concerning and consequential message about the future of democracy the other day. He said, and I quote, "If a judge tried to tell a general how to conduct a military operation, that would be illegal. Judges aren't allowed to control the executive's legitimate power." And more people need to be talking about this, because what he's suggesting would be a constitutional crisis. And scholars and Congress people are calling JD out, saying, how could you suggest something like this? Aren't you a lawyer? And yes, he is. That's the point. He went to Yale Law School, where I'm sure he spent a lot of time studying nuanced, theoretical, constitutional concepts, some that are so novel that haven't been used before. And I know this because I also went to Yale Law School, where I focused in constitutional law and studied with some of the same favorite professors that JD had. So I can tell you that the quiet part that JD is not saying out loud that would make all this possible is a conservative legal theory known as the unitary executive. Daria, what's the unitary executive theory? Most people haven't heard of it because they don't teach it widely in schools, but I have talked about it in a previous video because it was the underlying concept upon which Project 2025 was built. But now that it's real and here and DJT is the president, I'll decode it rather simply because you need to understand how all of this works. Okay, so background. The unitary executive theory was actually created by a Yale Law School professor who was also the founder of the Federalist Society. Its prominence dates all the way back to 1984 in the Reagan era and the rise of the Heritage Foundation. The theory basically argues that the framers, particularly everyone's favorite, Alexander Hamilton, in writing the Constitution in Article 2, called for a strong unitary executive with complete control under the president. It mainly comes from the language in Section 1 here, known as the vesting clause, which reads, "The executive power shall be vested in a president of the United States of America." And it's read in combination with the take care clause, which reads, "He shall take care that the laws be faithfully executed." So reading this together, essentially under the unitary executive theory, the president himself is in charge of the executive branch. And their argument is his wishes and control alone serve to counterbalance the two other branches of government. All of this is from Article 2, which is why you may have heard DJT say on multiple occasions, I have Article 2. This is what he's referring to. This is what he's talking about. And while this all started in the Reagan era, the president most famous for using the unitary executive theory was President George W. Bush. It allowed him to make broad national security decisions without congressional oversight. That's how we got the war on terror, surveillance program, intense interrogation tactics, and other questionable government policies. Now with DJT, one of the main ways he's trying to use the unitary executive theory is through Elon Musk and Doge, as they're attempting to eliminate jobs and take control of government agencies like USAID. But now what JD Vance is calling for is pushing the theory to new heights. Federal judges around the country are challenging and blocking many of DJT's executive orders. And the Don and his pals, Elon Musk and JD Vance, are not too happy about it. So what happens if, like JD suggests, the president decides not to follow a court's order? When someone defies a court order, judges have the power to hold that person or people in contempt. Then usually marshals are sent out to make them comply. Now you ask, who controls the marshals? That would be the DOJ, the Department of Justice, which is under the control of the executive, DJT. And do you really think that DJT's Attorney General, Pam Bondi, is going to send law enforcement after the president, her boss? No. So what can they do? What can the courts and judges do? And the honest answer is not much. Now, has this ever happened before? Well, once, in 1832, with then President Andrew Jackson. The Supreme Court in Worcester v. Georgia ruled in favor of Cherokee rights. When President Jackson responded, Marshall has made his ruling, now let him enforce it. So Andrew Jackson completely ignored the court and removed the Native Americans from their land, forced them out west, and that's the Trail of Tears. And if DJT does ignore a court order, it would place the president even further above the law. And we already saw with the presidential immunity decision, completely dismantling the separation of powers and any notions of checks and balances. This was DJT and Project 2025's agenda from the get-go, and we're witnessing it play out.